All right, returning to plea bargainings. We can think about plea bargainings in reference to decision making. The plea bargain process is largely informal. It lacks guidelines, and it's certainly highly discretionary. The role of the defense counsel is an advocate for the client to obtain the best deal possible, and this ensures the defendant understands the charges and punishments that are being brought against them. There's of course a role for the judge. The ABA opposes judicial participation in plea negotiations, but it approves the plea bargain. Research suggests that the plea bargaining process is rather complex, and it's essentially a negotiation between prosecution and defense. The factors that influence this negotiation include the offense itself, the defendant's prior record, age of the defendant, admissibility of available evidence, the effects on the victims, and sometimes, unfortunately, the prosecutor's political aspirations or promises. The defense counsel must explain to the defendant that by pleading guilty, they are waiving certain rights. These are rights that are constitutional rights, and they're required to communicate all plea bargaining offers to the client, even if they believe those offers to be unacceptable. Some worry the system is too victim-driven because prosecutors ask approvals for pleas from the victim or the family member, but statutes do not require the prosecutor to defer to the victim's wishes, and there are no legal consequences for ignoring the victim in the plea bargain process. There's also some potential reforms to plea bargaining. One in negotiation oversight that provides consistency in plea bargaining cases and develops guidelines that parties must follow. And then we can consider banning the plea bargain altogether. When tried, it tends to clog the system. So if you ban plea bargaining, it clogs the system. We talked about this in a previous slide. Numbers of trials may increase, the sentence severity may change, and more questions about the right to speedy trials may arise if you take away the plea bargain. And ultimately, prosecutors just might dismiss more cases outright. Without plea bargains, the efficiency of the system starts to grind to a halt, and the system doesn't work the way it's supposed to. We need to take in consideration pretrial diversions. This is a non-criminal alternative to a trial, usually featuring counseling, job training, and educational opportunities. You could probably find things like this in the drug court process. It's established to reduce the stigma created by the formal process. It offers opportunities to the client to continue working and receive rehabilitation. And there's some disagreement over whether these programs are more successful than traditional justice processing. These programs also reduce the costs and alleviate prison crowding. Some are run by separate independent agencies set up with federal funds, but now are being continued with county or state assistance. Some are part of police prosecution or probation departments' internal structures. Some are a joint venture between county government and private nonprofit organizations. National evaluations concluded these programs are more successful at reducing stigma and recidivism than traditional justice processing. Some fear that it could also widen the net of the justice system. However, rigorous evaluations have shown that given the proper treatment, some types of offenders who are offered a place in pretrial programs can significantly lower rates of recidivism. This brings us to the trial. The trial is a criminal trial, or a criminal trial is an open and public hearing. The intention is to determine the guilt or innocence of a defendant, and some defendants can waive the right to a jury trial. Which brings us to the potential of a bench trial, where the judge renders a verdict. A bench trial is a trial presided over by a judge only. This situation occurs daily in lower criminal courts, where the judge may initiate a number of formal or informal dispositions, including dismissing the case, finding the defendant not guilty, finding the defendant guilty and imposing a sentence, or even continuing the case indefinitely. And then it finalizes with adjudication, where the determination of guilt or innocence in the formal process is defined. Legal rights during a trial: the right to counsel at trial, known as pro se defense, the right to a speedy trial, the right to a public trial, the right to be convicted by proof beyond a reasonable doubt, as opposed to a preponderance of evidence. This is a great flowchart of evidentiary standards of proof and degrees of certainty. Look through this table, check out the standards, definitions, and rulings, and be familiar with it as we move forward. Sorry, this, on the other hand, is a flowchart of the process. We start with voir dire, which leads into a prosecutor's opening statement to the jury. Sorry about that, folks. Then we got the defense attorney's opening statement, the prosecutor's presentation of evidence, the defense attorney's cross-examination, which leads to the defense's presentation of evidence. Of course, the prosecutor gets a chance to cross-examine, which leads to the defense's closing statements, the prosecution's closing statements. This leads to the judge's instructions to the jury on the law, evidence, and standards of proof. The jury deliberates, comes out, pronounces the verdict, and then we move into judicial sentencing. When we think about the trial, there's a trial process. We have jury selection, opening statements, prosecution's case, the criminal defense, and closing arguments. In reference to the jury selection, in both civil and criminal cases, jurors are selected randomly from licensing or voter registration lists. Many of you know, you gotta appear for jury duty, and then you go through the process of whether you're selected or not. The opening statements made by the prosecutor and the defense attorneys, they use the time to outline the cases. Then you see a prosecution's case, a criminal defense case, and then the closing arguments. The instructions to the jury from the judge, these are specific instructions that the jury uses during the deliberation process. Prosecutor and defense attorneys are often able to negotiate the actual words used in the instructions. This is telling the jury, who may not understand the law, what exactly the law allows them to do and not to do. The deliberation and the verdict, this is where the jury deliberates or discusses the evidence in private. Occasionally, a jury may or may not be able to reach a unanimous verdict. In this case, the court may deem the jury hung, and the trial process may begin again with a different jury. In a not guilty ruling, the defendant goes free. In a guilty verdict, the defendant moves on to sentencing. Here, the defense can try for the jury nullification tactic, which is to ask them to acquit the defendant who is guilty because the law is unjust or does not apply. Next step is the sentence. In cases where the defendant is found guilty, either the judge or the jury decides the sentence. The sentence itself is determined by the statutory requirements for the particular crime as established by the legislature itself. And then, of course, we have appeals. A post-conviction appeal is a request for an appellate court to examine a lower court's decision to determine whether proper procedures were followed. A writ of habeas corpus is the primary means by which state prisoners have their convictions or sentences reviewed by the federal court. It seeks to determine the validity of a detention by asking the court to release the person or give legal reasons for incarceration. One great example of the appeals process is the President of the United States is being asked by the state of New York and by the House of Representatives to provide his tax returns to shed light on some of the charges that are being brought against him. The president's legal defense team took this to court, and they lost. And then they appealed the decision to the appeals court, and they lost again. So, just because you go to the appeals court doesn't mean that you're going to overturn the previous ruling. As a matter of fact, most appeals courts don't overturn previous rulings because most judgments are done through proper legal channels, and most defendants are not in a situation where a gross injustice was dealt to them during the trial process.